So good afternoon. In today's video, we'll be looking at dissolution of marriage. Dissolution of marriage. And we're trying to look at this in the context of Nigerian law. How do you end a marriage? Our previous lessons would have made us to understand the fact that in Nigeria, the family law system is a plural legal system that encompasses marriages under customary law, marriages under Islamic law, and marriages under statutory law, what we call English marriage. And what law governs a particular marriage is determined by the law under which marriage was celebrated. So with that understanding, we should then therefore realize that dissolution of marriage is also governed by different systems of law. In this presentation, we'll give a brief introduction of what we'll be going through in the course of the next set of interactions. And essentially, we'll be looking at the statutory marriage. For the aid of our understanding, I will share my screen. Okay. Just a moment. So so we have our slides ready. Marriage is like this block. It was once a composite whole. No challenges, no problems. Then before you know it, some marriages begin to break, begin to crack, begin to see cracks. And before you know it, the parties are ready to go their separate ways. What role does the law have to play with this kind of setting, where parties to a marriage want to go their separate ways? Like I said earlier, first you determine what law governs their system of marriage. If they are married under customary law, then you look at the customary law and look at how marriages are dissolved. If they are married under Islamic law, look at the Islamic legal system and determine how marriages are dissolved, stipulations of Islamic law. If they are married under the Marriage Act, then you check the Matrimonial Causes Act for how to determine the processes for bringing the marriage to an end. The essence of this interaction is therefore to understand how a marriage can legally break down and be dissolved in law, to get the parties to a state where they do not owe themselves any other obligations beyond what the law has stipulated. My name is Professor Oluwakemi Adekile from the Faculty of Law, University of Lagos. When there is a marriage, so many things are in place. The parties, of course, have an undertaking to be married to each other as under husband and wife. Sometimes we have children, sometimes we have properties. So many things have come into play in the course of their married life. Some marriages are there for years before the cracks begin to appear. Some do not have any cracks and it's still death to them part. Some, a few years, even a few months. So before you have the different kinds of marriages, and these marriages are dictated, or the rules that dissolve them are dictated by these various forms of laws. So you have different phases, different laws. Our phases may be the same at times, but the laws that govern us may be different. So even within Nigeria, we may all look the same, but the legal system, when it comes to the family law system, may differ as to what the law expects of us. Today's presentation would concentrate essentially on the statutory marriage. I will briefly look at how the evolution of the English divorce system, from which the Marriage under the Marriage Act evolved. Subsequent lectures will be looking at Islamic grounds of divorce and types and procedures for divorce. And we'll also look at customary law marriage and the grounds for divorce. But in today's presentation, we'll very quickly look through how evolution of divorce. Because it may surprise you that it has not always been the case that divorce is available. So these are our learning outcomes for this presentation. To understand differences in divorce laws under Nigeria's legal system, apply applicable laws at the end of the course. You should be able to apply the applicable laws to relevant case scenarios. When it relates to statutory marriage that we are looking at today, be able to apply the 2-year waiting rule and to understand the fact that it only applies to statutory marriage, to understand the concept of irretrievable breakdown of marriage or the statutory marriage, to appreciate the meaning of grounds for divorce under the Marriage Matrimonial Causes Act, and to apply the bars for divorce, because we need to understand the fact that though a marriage may have broken down irretrievably according to law, there are still some things that could prevent the courts from allowing the divorce to take place. And at the end, if you have been able to develop competencies in advising on divorce law in Nigeria, these are our resources for this course: the Matrimonial Causes Act, Marriage Act of Nigeria, and other cases and recommended texts. Evolution of divorce law under statute. Like I said, like I made reference to just now. Divorce law is tied to church history, and church historically did not permit divorce. It was seen the Christian faith saw divorce as contrary to their beliefs, and so divorce was not permissible. Marriage was indissoluble, and because of this indissolubility, you find situations where the marriage is in actual fact broken down. But parties, because the law did not permit them to divorce, went their separate ways. Marriage different, quote and unquote, that is, they just cohabited with different people. And so you have groups of relationships here and there that don't have any legal standing in law. That was the situation that people had in Victorian times. Eventually, the law began to change, realizing the challenges that are created when people have gone to different kinds of relationships without legally determining their previous relationship. So the divorce history is tied to church history. The ecclesiastical courts did not only grant decree of judicial separation, which permitted the parties to go their separate ways, but not legally divorce. They could not remarry. Eventually, English law began to permit divorce by private act of parliament. Parties that needed to get a divorce could go to the legislature and obtain a bill for an act to get a divorce. That was a very expensive procedure. It's very, very extremely rich to afford it. And when they're able to get a law to that effect, to say that Mr. A is divorced Mr. B, then they can be legally divorced. That was another stage in the evolution of divorce law in English law. Then you had the era of force, where the law began to realize that divorce has to be permitted, and the divorce courts were created. The divorce courts were created, and these divorce courts and the English Matrimonial Causes Act of 1857 created the divorce courts and permitted divorce for men and women on different grounds. While a man gets a divorce for a matrimonial offense, like adultery, for instance, like desertion, a woman, a wife, don't get a divorce unless she's able to show that the man has committed adultery and other matrimonial offenses in conjunction, like, that are regarded as quite very grave, very grave. So adultery alone was insufficient to get a woman a remedy in the English courts as at that time. And that discrimination, which was, clear in the English society regarding gender, was also manifest in the divorce law. Eventually, under the Lord Hubert's Act of 1937, divorce be granted for matrimonial offenses like adultery, like desertion. It was regarded as an offense, especially adultery, desertion, cruelty, and incurable insanity. Those were the grounds on which forced divorce to be granted. The law continued to evolve and eventually allowed women and men to obtain divorce on the same grounds. this evolution was not just a day's event, it was subject to different debates and, interactions of society with law to find out what is the best way to approach a divorce. And at the end of the day, the law permitted the era of fault, divorce by fault. The fourth era was also seen to be problematic because of the fact that when you have to prove that someone has committed desertion, adultery, cruelty, and what have you, all these kinds of facts that you have to bring before a divorce court, it costs so much acrimony. Don't forget that marriages probably have children. I can imagine the kind of, opprobrium, distress, and what have you that are faced by family members when parents in couples in attempt to obtain a divorce begin to reveal things that ordinarily are supposed to be in the private sphere. So it was eventually agreed. English society tried to reform the divorce law, and the Archbishop of Canterbury instead a committee to investigate this issue of divorce and make its recommendations known to the government. And it was realized that there is a need to move from the fourth era to move to the era of irretrievable breakdown. That look, when you are coming to obtain a divorce, the marriage is broken down, it's broken down. Why do you have to reveal all these faults? Who is adulterous, she's been cruel, he's been this or that. These are, evidence. These are evidences of the facts that a marriage has broken down. They are not really the cause of a breakdown of the marriage itself, but they are just manifestations of a marriage that has broken down, like the brick that I showed you earlier. That brick, it's cracked because of something fundamental. The crack itself is not the cause of the brick going apart, but something caused it to crack. And that something is what is called irretrievable breakdown of marriage. And that's how that concept of irretrievable marriage, because the irretrievable breakdown of marriage came about in English law and still was incorporated into Nigerian law under the Matrimonial Causes Act of Nigeria of 1970. We'll be looking at that Matrimonial Causes Act, for what are the considerations that we would have regarding the dissolution of marriage under dissolution of statutory marriage, the marriage under the Marriage Act, the marriage that normally you say is an act marriage, or is a Christian marriage, or is a sort of marriage. In summary, we can say that the laws related to dissolution of marriage are a reflection of different plural legal systems in Nigeria, and they also reflect the history of social development. Law continues to respond to social change, and that was what happened in English society. Of course, Nigeria being a creation of, Nigeria being a colony of Britain, when it's enacted the Matrimonial Causes Act of 1970, imported, so to say, if I use that language, this ideology of irretrievable breakdown of marriage. And what you find under the Matrimonial Causes Act is that it's usually said that the only ground on which you can dissolve a marriage under the law when it relates to statutory marriage is that the marriage has broken down irretrievably as stipulated under Section 15 of the Matrimonial Causes Act. What is irretrievable breakdown of marriage? Those are the things that are regarded as facts that are used to determine that a marriage has broken down irretrievably. I look at Section 15(2) of the Matrimonial Causes Act for these facts. So these facts will be the basis, the considerations that we've taken in the course of our next presentation. I would expect, of course, that these presentations presupposes that you have a copy of the Matrimonial Causes Act, and that you are able to have a robust interaction with that act before we begin the presentation. So one of the things I would note about the Matrimonial Causes Act that we can just note before we go out is the fact that under the Matrimonial Causes Act, which relates to statutory marriages, Only a court of law can dissolve a marriage, only a court of law. And the court is the high court of the state. And the provisions of the MCA must be complied with before you can get that divorce order. So these are some of the things that we'll be looking at. After that presentation regarding statutory marriage, we look at the Islamic marriage and how you can dissolve the marriage of those who are married under Islamic law. We'll also look at customary marriage and determine how marriages under customary law can be determined. So these are the objectives of the subsequent presentations that we will be having. I will enjoin you to join me as we go along. Once again, my name is Professor Oluwakemi Adekile from the Faculty of Law, University of Lagos. Thank you.